Hello and thanks for joining us for today's webinar, Data Governance, Why Data Retention and Deletion is Fundamental to CLCs. My name's Kate Scanlon and I'm one of the Capacity Building Coordinators at Community Legal Centres Queensland. I'd like to start by acknowledging the traditional owners of the land of which we're meeting on today and that are holding the webinar in Meanjin and Brisbane, the Turrbal and Yagara people. I pay my respects to their elders past, present and emerging and acknowledge that these are stolen lands and that sovereignty was never ceded. As this webinar is being viewed by people across Queensland and Australia, I also pay my respects to traditional owners throughout the country and extend a warm welcome to any First Nations people joining us today. Today, we're pleased to welcome Alec Christie, who is a partner at Clyde & Co. Alec has over 30 years' experience across many sectors in privacy, cybersecurity, digital transformation, and a range of other things. I'll let Alec tell you a little bit more about himself when I hand over, but before I do that, I'll just do some quick housekeeping. Today's webinar is being recorded, and we'll have the recording available for download from our website tomorrow. The PowerPoint slides will be emailed out to everyone who registered for the webinar, and they'll be also available on our website. We encourage you to ask any questions throughout the webinar. Simply type your question in the question box on the control panel, and we'll read them out. I'll hand over to Alec now. Thank you.
Thanks, Kate. Also, just before I kick off, I'd like to acknowledge the traditional owners of the land from which I'm coming to you today. I'm not in Queensland, which is the Gadigal people of the Eora Nation, and pay my respects also to the elders past, present and emerging. That's enough about me. You've got that, you can read it, and Kate, I'm happy for you to send out the slides. I hate talking about myself. The only thing I'll add is I am a self-declared privacy nerd, so apologies if this session is a little bit nerdy, but hopefully you'll get something out of it no matter what level you're at in terms of your CLC or yourself in terms of privacy awareness and experience. Next slide, please, Kate. Lofty aims. I won't read all these out, but hopefully some or all of these is what you'll take away after today. And as I said, very lofty aims, I admit. But the idea is that this will be at various levels, various speeds, whether you're brand new to privacy, whether you are an experienced amateur or a professional that's part of your day-to-day work. There will hopefully be something for you to take away from today in terms of new developments and some key risk mitigation strategies. Look, it's your session. Given it's a webinar, it's a little bit difficult to deal with questions, but if you put them in the question box, as Kate said, if she believes that there's one that's particularly pertinent to a relevant topic we're covering at the time, Kate, please feel free to interrupt me with the questions. Otherwise, we'll leave time at the end for questions. So let's get started. Next slide, please, Kate. And again, a little bit more, that was the objectives. This is just a very brief dump of what we're going to be doing today. And as you'll see, we've got some Q&A at the end. Running through these topics in the broader overarching topic of data governance. And data governance means different things to different people, but in a very real and everyday context of what I do, it's not simply advising on an overarching policy, which is often what a data governance framework used to be, but it's looking at all the bits that hang under that data governance framework, the relevant particular aspects, and in particular today's focus, as well as giving you some detail about some of the announced and agreed changes that will be implemented starting in August. We're focusing in on data retention and deletion as one of the most significant areas at the moment where people are getting themselves into trouble, and where if you spend some time and money in that area, you can significantly reduce your data privacy risk. Next slide, please. Thanks, Kate. So look, obviously, you know, everyone on this call should know that there is a Federal Privacy Act and how it applies. There's also various state acts, and there's one in Queensland that relates to Queensland government entities, New South Wales government entities, Victoria, etc. It's not in every single state, but there is something in most states. What we're talking about today and what we're focused on is the federal law. I've had a look at a number of your privacy policies, and you all declare that you are complying with the Federal Privacy Act and the APPs, or Australian Privacy Principles. So generally speaking, you're caught if you have a turnover of more than 3 million, you trade in information, or you're a health service provider, or you opt in. And whether you've officially opted in or not, if your privacy policy is telling the world that you are complying with the Australian Privacy Principles, the APPs, and the Privacy Act, then based on recent actions by the ACCC, you really can't resolve from that. It's a representation, and it would be misleading or deceptive if you were not complying with it, even though you say so. So that's not what we're talking about today, whether or not you're caught, but generally speaking, I just wanted to lay the ground rules. So when we talk about data retention, and this is always talked about in the same context now as data deletion or de-identification, it's that old-fashioned term from old data archivists when they were focused on keeping everything necessary for the particular business or organisation. So making sure that, you know, if your client came back to you after 30 years, I'm being a bit facetious, that you would have records there, and the business or organisation wouldn't skip a beat. So it was very much focused on the retention aspect, and it was very much looking at what was necessary for the business to continue BAU, to thrive, to move forward. But there was always an element in that of a then minimum term, which was the legal retention periods. Now, as you'll all be aware, especially in Queensland with your recent change to your Legal Profession Act, 713A, I think it is, where there are additional requirements being added to your obligation to keep client records for 7 years. There are always obligations in law of different types of records as to how long you had to keep them. Tax law, employment law, corporate law, a whole range of things. Now, they weren't focused necessarily on personal information, which is what we're going to be talking about today, but they were very much the type of records you had to keep and how long you had to keep them. So that has not changed. There is still this underlying aspect of legal obligations to keep records. And where you didn't have a specific legal obligation, there was a general rule of thumb, which we continue today, which is you look at the statute of limitations for the particular type of record and determine if it's related to a contract, or it was related to negligence or some other liability form, that you actually would keep it for at least the period of the statute of limitation, and possibly a 1 year buffer or more, just to ensure that if there was a claim relating to that, that you had the relevant information at hand. So then the privacy law comes along, and the privacy law, not just in Australia, in most of the countries around the world that have a privacy law, which is significant, hand in glove with the other privacy obligations around collection and use and disclosure, were the obligations to keep it secure and to delete or de-identify once it was used for the purpose for which it was collected. So destroy is the word used in our law, but most of us talk about deletion, destroy or de-identify. So destroy or delete has its common meaning, and it really does mean, and this is contrary to a lot of practice, to put the information in a state where there is no longer the ability to re-identify it. There is no names left in or other identifying information. So it's that concept of putting it out of reach, so it is not recoverable in the truest sense of the word. Now, within reason, as we know in the digital age, you know, there is no such thing as a true deletion. You know, you're not required to apply CIA level deletion tactics, but you are required in the circumstances to apply reasonable, and I would argue industry standard levels of deletion or destruction of the data, which are not nothing. They're not CIA level, but it's something, and the more sensitive the information, the higher the obligation is. The second part of that obligation, and we'll talk about exactly what that obligation is in a minute, is de-identify. And the de-identify is a much more complex term. It is very, very little understood across Australia. We do a lot of work with clients who think they've de-identified, but they haven't. And the issue is this: de-identification can be used as a useful way to keep generic information, to move forward, to do analysis, to report to government, givers of grants, etc., about demographics, about whatever it may be. But it's very fraught. It comes with a requirement that is not just removing Alec Christie's name from the data. If you have kept in my email address, for instance, it probably, alec.christie@clydeco.com. I mean, it's identifying me. If there's anything else in the information which itself or with other reasonably available information could identify an individual, even if it's a wrong identification, that's important to know. It doesn't have to be perfectly good. You could misidentify me as relating to some information based on the characteristics in there. Then that is not de-identified. It is never going to be de-identified, and you have not deleted or de-identified it in accordance with your obligation. So let's talk about APP 11.2, because that's the obligation. And it is the obligation, and I'm just going to make sure I read it properly, but once no longer needed for the notified purposes of collection, that is, you've already used it for that purpose, and you are no longer required to keep it in an identifiable form under an Australian law or court or tribunal order, then the obligation, the legal obligation, is for you to delete, /destroy, or de-identify that information. Now, it's important to understand that minimum, reasonable steps, I think at a minimum, is what we're talking about today. There's been a number of Privacy Commissioner determinations and guidance that effectively, one of the few ways they consider you're able to do this, and they've not really identified much else, is by way of a data retention schedule and a data retention and deletion plan. Now, they're called different things, but effectively they're documents that assist you by recording the specific legal requirements or hold periods, and they also have a plan which talks about and covers how you actually implement that DRS, how you actually call things up to be destroyed, at what time, how it's done, who's responsible for it, what you do to implement that DRS. So that's it in a nutshell. The second last one, a lot of people say, well, that's just pure compliance. Well, actually, there's a lot of governance benefits in doing this exercise, which is a data retention destruction plan and a DRS, and we're going to talk a little bit more about them. But there's a lot of benefits, because what you effectively do is you get to know your data. And I know that sounds silly, but trust me, for most clients, and I'm sure for most of you, you've got a fair idea of what you collect, you think, but there might be a particular aspect or function of your centre that actually collects something very different. Or you may be running amok with duplicates that you weren't aware of because of the way things are done. So this process, when done well, actually helps you manage your data better, reduces duplicates significantly, which is the whole point. You also, where you have legacy systems, often in business clients, they have kept legacy systems. They've bought a business, or they've got an old system, they've moved to a new system. They keep it just in case the data is needed. So by knowing what you've got and where you've got it, and whether you've got a duplicate of it, you can also look at whether you need to keep those legacy systems running. You can significantly reduce the amount of information you're holding, and therefore reduce your operational costs going forward. In particular, you can significantly minimize the risks of a high impact of a data breach, because you have reduced the amount of data and personal information that is available. And of course, if you do that, it's a sign of privacy maturity, it's a sign of goodwill. So it's going to feed into any fine that may come your way under the privacy law for not doing what you should have. And it is a key important aspect to avoiding or minimizing those fines. So again, just quickly, the Medibank fine action, which you've all heard about in the press lately, that certainly is something that where they're focused on the security part, which is APP 11.1, reasonable steps to secure. But I've got no doubt, based on the previous public information from the Privacy Commissioner, they're also going to be hammering them on the fact that they had far too much information. Next slide, please. Okay. So we've already started this, but I think it bears repeating. Know what you have data-wise. That the whole point of privacy, or the whole foundation, is to apply your obligations across all of the personal information you have. I know it sounds simplistic, but if you do not know what data you have and where you have it, it's almost impossible to actually apply your privacy obligations across all of those. So GDPR, for instance, actually puts this front and center with a number of obligations about knowing where your data is, how to remove it when requested. Now, we don't have the right to be forgotten here, but again, there's a number of requirements in GDPR because they have a number of obligations to go through their entire collection of personal information and delete if Alec Christie asks them to. Now, we don't have that, but we do have that APP 11.2. So when the time comes that you've got to delete, then you've truly got to delete, destroy, or de-identify the information. This exercise sounds a behemoth, and it theoretically is. You are reducing that monster a little bit by focusing on your personal information rich assets. So again, we don't suggest that you go back and recreate an entire data retention program simply to deal with privacy compliance in APP 11.2. What we suggest is, if you've got anything like that, you can use it to assist you, but you're looking for the personal information areas that you collect, where that data is. And I suppose it's important to then work out what records they exist in, because the laws that have legal hold periods, the old work on data retention is always focused not on personal information itself, but on the type of record. So what the DRS addresses, because it has to look at what the hold periods are, is the type of record. What this exercise is doing is focusing on which of those records carry the most personal information or PI rich information that we have to address, that we have to have hold periods for, that we have to make sure we delete or de-identify at the relevant time. And it is that which reduces it slightly. Now, obviously, one of the major aspects for you guys will be client records, and you'll have obligations under your own professional legal profession act. You'll also have others depending on the type of information that's in there. So again, you need to identify those categories. And when there's no express statutory period, I mean, we call it better practice, but you need to be thinking about the potential for a claim against you, or if it's in the file that you're dealing with, which gets a little bit complicated, the second level, whether it's information about a potential claim that a client of yours may have or that someone may have against them, then you've got to look and think about the statute of limitations here. And you've got to think that you should hold that for the statute of limitations period at least, and probably 1 or so years after that to make sure. So again, that's where the art comes in, because you're not dealing directly with a very specific statutory obligation. Some of them are, which is fabulous. And some of them, like your 713A Legal Profession Act, impose additional obligations, not just 7 years from memory, but also an obligation to notify, get consent or approval to delete or destroy. So that's where a DRS comes in to build in all of those obligations and requirements. And it really does focus in on what the information is that is relevant in terms of the personal information. But let's get back. Anything else? Well, yeah, I've talked about 713A of your Legal Profession Act, but there's also this thing called litigation hold. So your DRS and your DRDP operate as normal. There should always be a human involved in the decision, because you've always got to take a view that even if it's automated to pull up the fact that this data or this client file, it's now beyond 7 years, it can now be deleted. Someone needs to focus, hang on a minute, they're suing us, or hang on a minute, there's a claim made, or there's a claim threatened. And what we call a litigation hold, and I'm sure you're aware of that, is in most states and territories, it's illegal to destroy information which is the subject to a threatened or existing claim. So that needs to be the overarching over the top of this, so that you always need to take that next step. And again, the claim could be a Royal Commission announced. It could be a specific threatened claim against you by a client or two, or by a client. It could be something else, some sort of other commission of inquiry. So again, you need to build that in so that there's always a human in the loop saying, hang on a minute, there is a claim here, do not delete this client file or this personal information, but happy to do the rest. So then we've talked about creating this data retention schedule and the best way to implement it being, in fact, a data retention and deletion plan or policy. People call them different things. The DRS is the engine for this work, as we've said. And look, I'm not sure whether this will get picked up, but I've got a sample of one. No, it's going to be really tiny on my screen. But look, it basically covers the PI-rich type records that you're dealing with, the key aspects of personal information that they contain, the actual legal hold period for that record, or the better practice statute of limitations, whichever is relevant, when the period starts to run, because that's also important. Again, with whether it's limitations or whether it's an express statutory hold period, you've got to know when time starts to run to calculate when it finishes. And obviously, look, we're lawyers, and I'm speaking to lawyers, so I think you'll understand this. We also put a column at the end which actually has a little bit of a description as to why or what particular law this relates to. So the point is that these statutory periods occasionally change, especially if you're dealing with children or vulnerable persons, and children in particular, especially if you're dealing with alleged abuse of children. Western Australia now has an unlimited, we're saying 100 years, but actually if you read the law in WA, there is no limit to how long you need to hold this information for alleged abuse of children or information relating to that abuse. So each state and territory will change, so you need to be able to have that reference as to where and what the particular hold relates to, why you're saying it's 7 years or why you're saying it's this, so that you can update and do that. And again, let me caution you all, there might be other particular areas, but if you're dealing with children, in addition to whatever client hold obligations you have under your Legal Profession Act, most states and territories are now expanding really for a long time how long you have to hold that information. There's also relevant in some states for health information, but the Royal Commission into Child Sex Abuse mentioned at least 45 years. That's the rule of thumb, but some states, as I say, are now implementing a longer hold period. So on top of the DRS, the thing that then implements it and makes it usable in a day-to-day sense is this data retention or deletion policy, data retention and deletion policy, which actually then implements that DRS by explaining who's responsible for what. What do your frontline staff have to do? What do your lawyers have to do? What do your admin people have to do? Who is it pulled up to be asked, should this be deleted? What are the carve outs? What is the process? And we suggest also technically how this information will be deleted or de-identified. So it's a whole package to meet and your requirements. The DRS is attached as a schedule. It's something you could deliver to a privacy regulator, and I know that's not why we're on the call. We all want to do better, but it does help in any investigation. But in addition, it's your sort of one-stop for how you as a community legal centre are going to manage this, and how you're going to get your people to understand what they need to do in order to progress this. Next slide, please. Okay. So I've banged on about that, probably out of order, but why is he talking about this so much? Why is this such a big deal? Why did Community Legal Centres Queensland ask for this session? Well, it is one of the hottest issues. The Medibank fine action has sort of pushed it a little bit to number 2, but it will bounce back, I promise, when we've all forgotten about Medibank. It is the most significant. Those high-profile breaches 18 months ago and the ones that just seem to keep happening, all of them have, whatever else they have as a potential alleged breach of privacy, they all have this concept that they have held far too much personal information for far too long, and they are going to get hammered for it. So when the first 4 back 18 months ago happened, a very rough rule of thumb calculation, please don't quote me on this, please don't hold it over me, but we sort of, when we added up all of the individuals that were impacted by those 4 data breaches, it was actually 2.5 times the entire population of the country. So everybody, including children and newborns. So it was ridiculous that 4 companies had data breaches where 2.5 times the population were impacted by those data breaches. So it obviously, and you saw the press at the time coming out about people complaining, I haven't been with X for 10 years, or I haven't been with Y for 15 years. Why do they still have this information? So again, this is an issue that the Minister of Home Affairs stood up and berated a number of those original data breach suffering companies, has continued to do that recently, and has spoken about some of the Medibank action. So again, it's a very high profile thing, and it's certainly, in all honesty, one of the things that we tell to people, if you only have a limited budget, if you can only do one privacy related thing, which I suggest you don't limit yourself to, but if you do, this is what you do, because it significantly reduces risk. And you'll see those sort of indented dot points there as the sort of things that it can help you with. But from a risk minimization and management point of view, getting rid of the data you shouldn't have, that's illegal to keep, is a significant way of managing risk, avoiding significant fines or any fines at all, and actually doing better for your clients, your stakeholders, actually making sure that you are looking after their personal information just like you look after them legally, with their claims, their issues, their concerns. This, on top of this, we have a new privacy commissioner, and I could make a very bad dad joke. Her surname is Kind, Carly Kind, and she is kind in name only. In the privacy sense, she's already shown, I'm sure she's a lovely person, she's already shown that she's got a slightly different attitude than the previous privacy commissioner. She's been directed by the government to be more enforcement heavy and focused. So you can expect this incredibly clever person from a human rights law background to be a lot more focused on enforcement. And I think you'll see her use the announced changes in the fine space a little bit more than the previous privacy commissioner would have done, I suspect. So in talking on fines, just so you know, from mid-December, the government didn't even wait for the Attorney General's Privacy Act review to come out. They increased the fine some 25 times for serious or repeated infringements of privacy. In other words, breaches of the Privacy Act or APPs, from up to, at that time, 2.2 million to up to the greater of 50, that's 50 million. and 30% of revenue for the longer of 12 months and the length of the breach. So again, it's a high bar, it's serious or repeated infringements or breaches of the privacy law. But again, a 25 times increase, I think, shows you the sentiment of the changes that the government is bringing in and their intention for it to be enforced. But perhaps much more significant to most of us, most of my clients and most of you, is the fact that they have announced and agreed that they will introduce 2 more levels of fines. There's a mid-tier level, which is, again, probably going to go through the court system, hasn't been finally decided for them to apply it, as the big one is, but it's for, you know, not necessarily as serious and as not necessarily repeated breaches of the privacy law. So things that are a problem, things that may cause some harm, but are not at that serious category. Now, at the moment, the talk is that that will be around a $625,000, $650,000 fine, and it's likely that we'll have to go through some form of court or magistrate or tribunal to get that awarded. The, I think, much more significant tool that will be used by the Privacy Commissioner is they've introduced what they call a low level or administrative fine, which will be leviable by the Privacy Commissioner herself. She will not need to go to court. And the way it's going to work is and the way it works in other areas in Australia and certainly overseas for privacy, is a concept of an infringement notice. You will get told in a notice that you are failing, you do not have a data retention policy, data retention deletion plan and DRS, or a data breach response plan. You'll be told of some administrative failing, and you will have a certain period of time, often 30 days, to comply or start to comply with that. Failure to comply, and you then automatically get fined, and at the moment they're talking about that at about $125,000. So again, if I were the Privacy Commissioner, I would be looking to get general compliance up in a whole series of these infringement notices, once it's passed, once they come in, to actually get the behaviours that I want and to get people to change things. Now, if you comply, of course, there's a cost to that, but you won't get fined, or if you start complying within that relevant period. But again, it will put you on the radar. It will mean that they will follow up and make sure that you are doing it. So be warned that that is a bit of a change in approach and attitude. And once these new fine levels, mid and low, come in, I think they'll be used a lot more than that massive fine. But again, the massive fine will be available for really serious or repeated infringements. Next slide, please, Kate. So we started already on the announced changes to the privacy law by talking about the fines. So I won't repeat those again, but just briefly, for those that don't know, under the Morrison government, this statutory review of the Privacy Act was initiated by the then Attorney General. It is something that, as many of federal laws, has a trigger that they must be reviewed within a certain period. That was looking pretty mundane, pretty boring, pretty average, a tweak here, a tweak there. Then, of course, we had an election. You had a change of government. There was a little bit of a reshape at that point, a little bit of a broadening of the focus with the new Attorney General. But then we had, before the report was handed down, those 4 really significant high-profile data breaches, and that just blew the scope and what they were focusing on right out of the water, completely took a left turn. And so what you then had was an AG's report that actually suggested 116 pretty significant changes to the Privacy Act. And what it said, which was the most worrying for those in the privacy know, is the intro started up from the beginning saying these 116 proposed changes are all to make us significantly more like GDPR, the European privacy law, than we are at the present. So that aim to be more like the GDPR was then approved in the government's response. So the government agreed to 38 of the proposals, pretty much as they were written. has agreed in principle to another 68. So there's only 10 that it hasn't addressed, and it just noted them. So I don't think they'll go anywhere, but all of the main ones were either agreed or agreed in principle. But what they did do is confirm their acceptance of the aim, which was to make us more like GDPR. So look, if you're not worried about that, you honestly should be, because it's a significant uplift in privacy compared to where we are now, and certainly it indicates an uplift in enforcement as well. Couple of the key ones for you all on this call that I've pulled out is, whilst there be no change to APP 11.1, the security obligation, and APP 11.2, the deletion de-identification obligation, there were a lot of submissions to the Attorney General from business that said, we don't know what those things mean. What are reasonable steps? What do we have to do? It's really unclear. So unfortunately, they've got what they wanted. The Privacy Commissioner has been directed, and there will also be some potential tweaks to the law to be more prescriptive. Now, again, there was always this ability to risk rate your response depending on the type of information you had, but this will be a lot more detailed, a lot more prescriptive, and therefore a lot less wriggle room. You will be told in many respects the sort of things that you'll have to do. And our guess is that these will be more onerous for a number of smaller businesses and smaller organisations than you would ordinarily have had to do. So unfortunately, because business said that over 24 years they didn't understand what their obligations were, the government's responded by saying, okay, well, we'll tell you, or the Privacy Commissioner will tell you. The accountability point, the second one there, it's always been in APP 1.2. There's always been an obligation to ensure that you've got in place practices, procedures and systems to ensure compliance with the organisation complies with the APPs. In practice, it's not really been that focused on. There's a couple of determinations from the Privacy Commissioner, but the announced changes will not change this, but the government response has clearly confirmed, doubled down, reiterated, told everyone this is there, it's important, you need to follow it, and has charged the Privacy Commissioner with ensuring that it's enforced. So this concept of your organisation being accountable, effectively in a company setting is the board of directors. In your setting could be those responsible for the oversight of the organisation. And again, it's not the board, for instance, using a short form, it's not the board who are responsible to do it on a day-to-day basis, but to ensure that their organisation or their company has in place the necessary mechanisms, policies, procedures that it should be done, that it should get there. So you're going to see a little bit more focus on that. And along with that, there's a couple of the others that were a part of that, which is the mandatory privacy impact assessments for high risk projects or activities. You've got also, consideration and recording of the types of purposes. And I'm going to do a little bit of a quick case study on that in a minute on the demographic information. And there's this overarching requirement that will be introduced to act fairly and reasonably. Now, that in essence is a concept that whilst your organisation may decide that it can legally do what it has to do, that it's looked at the privacy law, it can collect this, it can do this, it can disclose it to so-and-so, it has notified, there's now going to be an additional overarching, and that comes back to the accountability of the organisation, overarching requirement to probably, in colloquial terms, ask the question, we can by law, but should we, right? Is there something that makes this unreasonable or unfair to the individual concerned? This overarching, what do we need to consider? Yes, we could collect. Yes, we could disclose. Is that fair and reasonable in the circumstances for that individual, no matter where you get to from a purely legal context? And again, for a lot of lawyers, they're going to struggle, but for a lot of businesses and organizations, you're also going to have a great deal of difficulty. And that's where the accountability comes in. Your board or governing body needs to be addressing that and needs to be helping to lay some ground rules as to how that will be implemented. So before we get on to the demographics, it was a great question that came in much earlier than we started today, and I just want to address it. But children in particular, it's agreed in principle. The details aren't there yet, but one of the key cornerstone aspects is you must consider the best interests of the child. So not just a fair and reasonable test. Whenever you're dealing with children's privacy, whatever else they put in, and they will be putting in some obligations for anyone that deals with children's privacy, children's information, but you must always, as well as that fair and reasonable, stop and say, is this in the best interests of the child? So a much higher bar, and it's going to be something that will cause a great deal of difficulty in many situations. I don't think it should in your environment, because of course you'll be dealing with matters relating to children possibly, and you'll be right across the obligations, and you'll be right across the protection of that child, for instance. However, you just need to know that that has been agreed in principle and will probably come in the next 2 years. The first tranche are going to be put into Parliament in August. That was the announcement of the AG in a draft bill format. Now, going back to that second last dot point, consideration and recording of the types and purposes for PI. A lot of people have misunderstood this from the AG's review and the government's acceptance. This is not a general ticker box type approach. This is almost like a privacy by design concept. You actually, before you collect any types of personal information, as an organisation, and probably under the oversight of the governing body, have to consider what you're about to collect, why you need it, is there a better way of doing it, is there a less privacy intrusive way of doing it. It's an overarching obligation upfront to actually address what you're doing. Now, someone asked a question, I don't have all the details, about the demographic information you collect. So that's a classic example where you would sit down and think through something like as follows. Why do we collect the demographic? Well, because certain people that give us grants, or certain government agencies, or the Attorney General requires us to give certain demographic information. So you would then tease that out by saying, well, what is required? Does it have to be Alec Christie attached to that demographic information, or are they requiring aggregate, overarching reports? And if the answer is they do not specifically and expressly require it to be personal information, i.e. identifiable to an individual, then you then have to work out a way that you are going to collect that, process it, disclose it in a non-identifiable manner. Because what this obligation is saying, and arguably what you should be doing now, but certainly what you should do once this comes in, is determine the least privacy intrusive way. And if for example, the Attorney General of Queensland requests demographic information to establish patterns or plan or budgetary purposes, then arguably, unless they expressly say it, they don't need to know that it's Alec Christie or somebody else identified. So you would then have to work through as an organisation how you're going to do it. And it might be that you collect it when you ask me to fill out a form when I come to your legal centre. But then you've got to work out what you then do with it. And obviously, if my analysis was correct, you'd be deleting it off my file and putting it in an aggregated basis without a connection. Now, just a warning, some demographics, that's a very wide term, especially for smaller centres or in smaller rural areas, a particular demographic could actually identify one or two people in the category. So you've got to be very careful to always, and it may be an unfortunate thing that has to happen because you've got to report on that category, but you'll need to do everything you can to protect the identity of those people to the extent that you can. So again, what is the purpose? What has been asked for? What is required? And then how do you do that in the least privacy intrusive manner? And arguably that's what should be happening now, but definitely when this new change, this announced change comes in, you'll have no obligation but to do that. So look, briefly, the really big issue here is the impact. It's going to be a significant impact on business, organisations, legal centres, everybody, this is a really big uplift. People don't think it is because there's just going to be some guidance, there's just going to be tweaking here and there. I've said the main ones, but there are significant other things like changes to the definition of personal and sensitive information. So there are some really big issues. Next slide, please, Kate. Conscious of time, and I want to keep 10 minutes for questions. So just going through this, these are how you can prepare and be ready for the announced changes. And as I said, if you're not incredibly privacy mature, that is incredibly privacy compliant right now, this is going to be a really big step. And it's akin to the sort of hysteria that went around with good reason before GDPR came in. A lot of smaller and mid-sized businesses and organisations threw their hands up and said, hang on a minute, this is going to kill us. And it almost did for a lot of organisations and small and medium-sized enterprises. It is a quantum leap. And it's the sad thing that it doesn't really appear to be when you read the words and you read some of the discussion about it. But as I've mentioned to you, some of those overarching principles, the accountability, where you deal with children, that's going to be a parallel privacy law virtually for children. So these are really big steps. And I would argue, jumping to the bottom, one of the ways you can start to get your house in order, and perhaps the best bang for your buck at the moment, is this project where you look at your data, you do a DRS and a data retention and destruction policy to significantly reduce what you've got to apply these other things to. Look, I'd suggest that the next cab off the rank for many organisations is an independent review, not just what you think, not just what the governing body thinks where you're travelling, but an independent sort of assessment. Some companies call them an internal audit, whatever you want to call it, an exercise where you look at some of the key aspects of privacy relating to your organisation. And onboarding for community legal centres, I think, is absolutely essential. If you get onboarding right, you are 75% of the way there, subject to doing your DRS and DRDP. So that is sort of the upfront when you first collect it. If you get it right when you first collect personal information off me or whoever it may be, with the right policy, the right procedures, etc., you are well on the way to being very privacy compliant. Again, going down, did I mention the DRS and DRDP? Sorry, that's me trying to be funny. That is absolutely fundamental. A data breach response plan and third-party processor claims, so that when you use a third party, and I understand that you're going through or some of you are going through a tech refresh, a CRM platform, maybe a new one, you really should be looking at what the privacy obligations are. I still review contracts today with really big clients who are using a SaaS provider from the States or somewhere else. They don't even look at the fact that there is no compliance with Australian privacy law from that provider. They don't warrant it. They in fact tell you it's your problem, plus you've got to comply with the relevant US or European law as well. So look, really important that your third parties that deal with your personal information or your client's personal information need to have relevant clauses in there about all sorts of things, including data retention and deletion, about breaches and notifying you and cooperation, who's going to do it, but also general ones around, security, privacy compliance. And look, where you're in the space that you get government grants, state or federal, there are usually obligations in those contracts to do certain things. And certainly in my client base, we have a number of government-related clients or that do business with government. And I've got to tell you, 9 times out of 10, the restrictions and the notification obligations in those contracts are significantly more onerous than the general law. So really important. The last one I mentioned PIAs. Look, PIAs are coming in. They've been agreed that for high risk activities or high personal information rich activities, they'll be mandatory when they're legislated. But in the meantime, they're a really good tool. They can be done internally. You build a framework, you build a guidance, and you actually, for any new project, including this new CRM, you need to look at a privacy impact assessment to assess where there are problems. And it's a working document that will allow you to address those areas or issues and become privacy compliant. But it almost is that sort of privacy view of your project to ensure that you're not missing something from a privacy, security, regulatory point of view. Finally, before we get into questions, next slide, please, Kate. These are the key takeaways. We've discussed all of them. Again, DRS and DRDP gets another run. The independent review gets a run. I really do think you should be starting to implement PIAs in your organisation, and they can be done internally. Really huge projects probably warrant an external to do the PIA, but they can be done internally, and they're a really good thing to show a regulator. I sound defensive, sorry, I'm a lawyer in the space. It's a really good thing to show that you did a PIA, even if you've got it slightly wrong, which I don't recommend, but you go through the principles and work it out. The top one I would absolutely note: do not wait for these announced changes. Some of them have been hinted or rumoured to only have a 6-month transition period because they're just direction or guidance or things that are already there and slight tweaks. Most of them will have 12 months, but even that, if you're not privacy mature, you are going to struggle to meet these deadlines, trust me. And the biggest thing you can do to help yourself along the way is that data retention schedule, data retention and destruction plan project to actually get your house in order, or substantially smaller, in order to get it in order when the announced changes happen. Next slide, please, Kate, and let's have some questions.
Great, thank you so much, Alec. That was really, really fantastic, and it's great to hear all this information from you and to have so much expertise in this space. It's definitely a space that our centres have been really interested to learn more about. So one of the first questions we have so far is really focused on the fact that a lot of our centres are quite small, and that it sounds as though the obligations may be quite resource or personnel intensive for people to be able to try and meet them. So I guess the question is around it: is there any other, and this may be slightly outside of your scope, is there any other resources or support being made available by the state or territory governments, state and federal governments, to help people meet these obligations, particularly for small organisations?
Yeah, look, it's a really good question. And I think one of the sort of implied comments was to the Privacy Commissioner in the review, and the government's response was that they should be doing more to help small business and small organisations. There is a fair bit of information on the OAIC, Office of Australian Information Commissioner website, and some of the states and territories have some really good guidance. Of course, that's on their law, but it is quite similar. But again, I think you'll see a lot more information going on that OAIC website and a lot more guidance. Unfortunately, there's no magic bullet in terms of assistance, and there's been no talk like there has been in the past of grants for people to get up to speed or anything like that I'm aware of at the moment on a federal or state level. But again, as a grouping, I probably shouldn't be saying this because we'd be going for the work, Kate. But as a grouping, you might be able to do things as an entire group and roll it out. Now, again, it wouldn't be exactly bespoke, but to exactly what each centre is doing. But I'm sort of thinking off the top of my head that about 90% of what you all do is very similar in terms of MySpace. And you could probably do something, a really good project, maybe something for you guys to think about, Kate, and then roll it out to all the centres. So no matter whether they're larger or smaller, this is costly, it is labour intensive. But the DRS, for instance, we could probably put together something, or someone could for you, that actually, you pull your resources, get it once and roll it out to each particular legal centre. That's the sort of thing. But the day-to-day privacy management, unfortunately, one of the other changes coming through is to have someone not dedicated, but who is responsible for privacy officially. And so would have to be giving, I would suspect, at least 25, 30% of their time to privacy. So that's another thing that's going to impact resourcing. So no magic bullet, but as a grouping, I know some industry associations are doing this. You guys might be able to, you know, brief whoever it is to do this once and then roll it out to your members.
Fantastic, thanks, Alec. So as a bit of a similar related point, we did have a question asking if you'll be able to share the data retention schedule, or if you have any templates that you're aware of for the data retention schedule, deletion plan, or any privacy impact assessments.
No, sorry, I'm a private sector lawyer, so we don't share much at all. But no, look, they're very specific to the particular organisation or group of organisations. You can do it on a group basis. Funnily enough, we've done a lot of professional services firms, including those with offices in Queensland and most of the other states and territories. It is something they pay for, so it is proprietary and confidential. However, given what I said before, I mean, maybe if you guys, if CLCQ were thinking about it or could get some funding from the Attorney General in Queensland, as I said, assuming we can get some confirmation that what you all do is pretty similar, we could come up with a group one that could be done once and rolled out to all of you.
Okay, great. Thanks, Alex. So that looks like it might be all of the questions that we have coming in at the moment. If we have any others, I might get in touch with you, Alec, if there's just one or two afterwards. But thank you so much again for presenting to our members. Oh, sorry, we just have one more. Just quickly do that one.
Yep, sure.
So sorry, give me one moment.
And just while you're getting that, Kate, this is not meant to be too cute, because honestly, the way we got to this announced changes, and certainly privacy as a whole, this picture dramatically represents that whilst you can see where you want to go, certainly in privacy, it takes you a lot of twists and turns before you get there. So that's why it's there. It's not just because it's a relaxing picture. It's also because it's sort of indicative of the fact that we rarely go from point A to point B in a straight line in privacy. It takes quite a bit to get there.
Great, thank you. I might actually take this next question on notice just because of the time, and I might just leave things there. Thank you so much, Alec, for all your expertise and for presenting to us today. Before everyone goes, just a reminder to complete the feedback survey that will pop up on your screen once this webinar is closed. Your feedback is really helpful as it helps us work out how ways that we can improve our webinar program in the future. We hope to see you at the next CLCQ webinar. Bye for now.
Bye all.